This is Henry Frederick, and we're here again at the Brannon Center here in New Smyrna Beach, and with us for this open mic session before we get to the prime time debate, District 3 County Council. With me is Karen Foxman, who is running for a circuit judge in Group 18.
Correct.
Got it right.
You did.
Would you prefer to be called Mrs. Foxman or Karen or?
Karen is fine.
Okay. Karen, I know your husband, Matt Foxman, and I know your father-in-law, Judge Foxman, is retired. S. James Foxman. I never knew what the S stood for. What do you know?
Stephen.
Stephen. Well, that's a normal kind of everyday name. It's going to be tough for you competing. Your father-in-law the Justice Center is named after him, and your hubby's been around for a while. He's had some high-profile cases. But you have had some really extraordinary cases of your own in the last decade or so.
Yes.
From criminal to civil. You've worked for a couple big law firms too, Rice and Rose.
I was a partner at Rice and Rose, yes.
And now, are you back with the state attorney, or?
Yes, I'm a director of operations over Volusia County for the 7th Circuit State Attorney's Office.
And you also do some trial.
Well, I've been practicing for 18 years, and I've spent the majority of my career in a courtroom. I enjoy being in a courtroom. It seems to be where I fit. And so I, even as a director of operations, have picked up a couple of bigger cases that I wanted to sink my teeth into, and I've tried them, yes.
So I know you over the years from covering the courts myself, especially the criminal side. You've had a lot of big cases.
Yes.
How does that compare to the administrative functions that you have to deal with now with the state attorney's office?
Well, when you and I spent a lot more time together, you were doing the courthouse beat,
Right.
and I was trying a lot of cases. I've traditionally been known to try quite a few cases. And
yeah, you weren't too big on that plea bargaining stuff.
Well, yes and no. I mean, you have to pick your battles. I think in the criminal system, there's probably a top maybe 3 to 5% that really matter, that are harmful to the community. And your other cases, if it's somebody that deserves either another chance or they're otherwise a productive member of society, or maybe the facts of the case aren't really all that significant, part of being a good lawyer, I think, is evaluating your caseload and deciding where to pick your battles. And so where you saw me going to trial were usually the kind of heavier, when you say the bigger cases, they were the more violent or the more serious cases that were actually going. Because in my caseload, I did tend to work out the non-violent or non-harmful stuff. And then if somebody's a prison release reoffender or somebody with terrible history and, hurting somebody, yes, those cases do tend to go to trial.
Well, the one I can think of recently, I'm not going to get into names or any circumstances, but there was a man, a firefighter, who was accused of raping, I believe, 7 or 8 women, and he got, I think, 15 years, and there were 2 or 3 of the 7 cases, and very extreme situation where it was better for the women not to have to go through, I guess, the others to go through all this. And there was some criticism about a plea bargain. In this case, it worked out for everybody.
You're talking about the Daytona firefighter? Yeah. He actually got, he had 7 years, and maybe a little bit of change, but I think it was around 7 years prison, followed by a sex offender probation. And that wasn't my personal case, but of course as a supervisor I was, and then no, so to speak, I was involved. What we had was not your typical rape case.
Right.
And so we had to take into account some of the facts that may or may not help us and the victim's wishes. And yes, many of the victims did not really wish to be cross-examined or to testify in a courtroom. So you have some competing interests there, because you have to protect the community, and you also have to try to protect your victims from feeling re-victimized. And so in a case like that, you talk with all your victims, you weigh everything that they have to say, and you put it all together to try to figure out and evaluate where's the right place to land if you were to plead without putting the victims through all of this. So,
here's the biggest question. I didn't mean to interrupt you there, because these are all excellent responses. It's concurrent, it's consecutive.
Right.
I know what it means, but can you tell the audience
Sure.
the difference between the two? Because people think that a judge, well, why don't you give him 100 years? He's got
Right.
10 victims. It doesn't work like that, does it?
It can.
But
It
an
depends on the
extreme,
circumstance.
right, like you said, a prison release reoffender,
Correct.
you have some ups, things that you can
Right,
accelerate.
you can use different enhancements. What consecutive versus concurrent means is that when you have different charges, depending on your statutory max, so my example will be if you have 2 charges that are both third-degree felonies, the statutory max on each of those would be 5 years. If you sentence them 5 years concurrent, they serve both sentences at the same time, doing a total of the 5 years. If you sentence them consecutive, you stack them, so they get the 10 years.
When somebody is sentenced to 300 years, in Florida, there is no such thing as parole. Is it just basically because if they could get maybe an early release, those extra years would kick in?
In the state of Florida, you have to do at least 85% of your sentence, so you can't get out short of doing, no matter how much gain time an inmate would have, they can't get out short of the 85%. The 300 years that you may hear about usually has more to do with the appellate process. If one case were to come back on appeal, how much would this person do? And can we still make it more or less a life sentence if it's not a life felony?
And that's the other thing. I don't think judges, people understand that you as a prosecutor, or even as a defense attorney, on the other side, you can negotiate with each side in terms of what you want. But a judge is restricted by ranges, sentencing guidelines,
Well,
right?
we're still restricted by legal ranges. Can't give an illegal sentence. So we're restricted as well, but when I think what you're referring to probably is we have a scoring system for
Right, the
felonies.
score sheet.
And there's a score sheet which gives you a floor and a ceiling, essentially what you can or cannot do in the sentencing scheme. We can, as the prosecutor, we can agree to what we call a downward departure, or to go below the floor if there's a statutory reason to do so. So there are certain situations where we can agree to it. A defendant can also ask the court to do a downward departure and argue their statutory reasons to do it as well. It's just, it's easier, obviously, if the state agrees, because state agreeing to it can be a statutory reason.
Is it fair to say that when a judge wants to set he knows the community's outraged and he feels the plea bargain's not good enough, and they give him, okay, this is what you wanted, and if you don't want to go to trial, I'm going with an upward departure. I'm going to give him 3 years more than he wants. Is that more likely to get reversed by the 5th District Court of Appeal as opposed to going below?
Well, before 1998, we used to have a ceiling that would require an upward departure. Now the ceiling is the statutory maximum.
Right.
So they don't really need to do what we call an upward departure. There are certain very limited circumstances where if you score enough points, you can go higher than the statutory max, or if they're a habitual offender and they qualify. That's an enhancement.
I remember the Troll Brothers trial, and that may have been before the change in the statutory requirements, and I believe that was the late 90s. But Breeze had the